setting the record straight. Okrika and Diobu judgment can't be misrepresented. The record is clear.
Port Harcourt, Nigeria's oil city, River State's capital, and a melting pot of cultures. Yet, beneath its modern skyline lies a century-old dispute, one shaped by colonial agreements, court judgments, and competing historical narratives. This documentary sets out to establish the facts, separate truth from propaganda, and set the historical record straight. For decades, false narratives have circulated claims of sole and exclusive ownership of Port Harcourt by the Diobu people. Most recently, these claims were amplified by a self-styled ethnic organization known as the Iwo Development Mandate Organization, or IDMO. These assertions are not new. They are recycled distortions built on selective storytelling, misinterpretation of court judgments, and deliberate omission of historical documents and facts. At no time, either privately or publicly, has any Okrika king, chief, son, or daughter claimed exclusive ownership of Port Harcourt. Though such a claim by the Okrika people would not be outside of the ordinary, the Okrika people lay claim only to what is rightfully theirs, approximately 53% of the land on which Port Harcourt stands today. The Okrika man is guided by justice, fairness, and respect for truth, yet remains unwavering in defending his ancestral heritage. Did you know that the first name proposed for the land known today as Port Harcourt was Isaka, an Okrika community? Mr. John Igoson, who was the director of railway and works for the colonial government of southern Nigeria, also the team head who discovered the place now called Port Harcourt. In his memo dated 9th March 1930, on the report of a seaport and railway terminus for eastern portion of southern Nigeria, proposed in paragraph 12 of the said memo thus: as a railway terminus, this place on the Isaka Creek, and which I propose should be called Port Isaka, has the following advantages. The legal foundation of Port Harcourt rests on two principal agreements of 18th May 1913, 17th October 1913, and supplementary agreements of 2nd May 1928. These agreements were executed between the colonial government and 6 groups of indigenous landowners. The communities and groups were paid and compensated as follows. Okrika communities were paid £3,000, Diobu were paid £2,000, Omo Ime were paid £150, Omo Amasi were paid £100, Omo Biakpa were paid £100, and Ogumba received £300. Area acquired: approximately 25 square miles. The exact dimensions of the total 25 square miles of land acquired from all parties of the transaction. Names of communities written and pronounced as they appear in colonial documents only use Diobu because there was no mention of Rebisi in the colonial documents. Number of chiefs who signed on behalf of their respective villages and overall community: Diobu 7 chiefs, Omo Eme 5 chiefs, Omo Amasi 2 chiefs, Omo Biapan 3 chiefs, Ogunibia 3 chiefs, 18 Okrika chiefs. Why were the Okrika chiefs signatories to the agreement if they did not sell any parcel of land to the white men? Kalabari's sons, namely Chief Mariam Bray, Chief Lulu Wilbray, and others from Bakana, signed the agreement as witnesses before Gabriel Yellow, the district interpreter, before Judge J.H. Whitehead, the district commissioner. A total of £5,650 was paid for the total 25 square miles. Okrika chiefs were paid £3,000 because Diobu chiefs were paid £2,000. Why were the Okrika people paid more? Okrika owned 53% of the total 25 square miles. Map description: southern boundary, waterway known as Primrose Creek or Bonny River, approximately 3.5 miles. Western southwestern boundary, continuing along the Primrose Creek or Bonny River for 5.5 miles. Northern boundary, part 1, the rest northward along the west bank of Ilechi Creek for 1 mile, 800 yards to a boundary post marked A at Ilechi waterside. Northern boundary, part 2, east northward for 1 mile, 1073 yards to a boundary post marked B. Northern boundary, part 3 top, a straight line for 5 miles due east to a boundary post marked C on the Wochi Creek. Eastern boundary, following Wochi Creek for 1.5 miles. Southeastern boundary, following Okrika Creek for 6.5 miles to close the loop at the southern boundary. This land covers approximately 25 square miles. Geographical context: city, Port Harcourt, River State, Nigeria. Key waterways: Bonny River south, Ilechi Creek west, Wochi Creek east, Okrika Creek southeast. Pink, let surveyors and cartographers plot the above coordinates on a map and publish their findings. Since their execution, these agreements have never been nullified, cancelled, or overturned. They remain valid and binding to this day. As early as 1913, misrepresentations had begun. In a memo dated October 4, 1913, Chief Oju Daniel Kalio, paramount ruler of Okrika and the first political agent of Port Harcourt, in his memo dated 4th October 1913, wherein he raised concerns with the Governor General regarding the inconsistent behavior of the Diobu chiefs. Yet, even then, the colonial records were clear. Greater part of Port Harcourt consisted of lands belonging to Okrika communities, represented by their chiefs, as the colonial records reflect, for which £3,000 was paid. The Diobu people repeatedly sought to overturn these agreements through petitions, rent variation requests, and litigation. Their claim of sole ownership was tested and rejected by the High Court, the West African Court of Appeal, and finally, the Privy Council in England. In the case of Chief Joseph Bobo and 9 oaths against the Attorney General of Nigeria, which the Diobu initiated, one of the plaintiffs, Mr. Philip Chinua, gave evidence that no agreement of sale was ever entered into by the chiefs of Diobu and that the people who signed and executed the 1913 agreement were not Diobu people. However, under cross-examination, he later admitted to the court that the 7 chiefs and headmen who signed the agreement were their Diobu chiefs. The council's decision marked the final legal word. Port Harcourt was not solely owned by Diobu Rebisi, but by 6 groups and communities. In a further attempt to mislead the public, IDMO cited Supreme Court case ST2380 as proof of ownership. In truth, the case concerned a 26-acre parcel of land at Ozubuko, not the entirety of Port Harcourt. Even in that judgment, the Supreme Court affirmed the principle of dual ownership, recognizing Okrika communities as part owners of the land. Political office is not proof of land ownership. Despite claims to the contrary, Okrika's sons, Daniel Daka, George Otta, and Stephen Nonju served as mayors of Port Harcourt. The first political agent of Port Harcourt was an Okrika paramount ruler, Chief Oju Daniel Kalio. Before 1913, Ogbumutonchiri was exclusively Okrika land. Following colonial acquisition, the people resettled along Port Harcourt's waterfronts, where they remain to this day. They did not migrate. They were displaced, yet never disconnected. Like the proverbial blind men and the elephant, selective views have produced false conclusions. Port Harcourt is the product of multiple agreements, multiple indigenous owners, and documented colonial transactions. What cannot be disputed by law, by history, or by fact is that Okrika people are foundational owners of Port Harcourt. And this truth was reinforced and re-echoed in 1977 in the High Court case number PHC/45M/76 between Chief Ingere Rowlands and 10 Oars versus Attorney General of Rivers State. In his judgment, late Honorable Justice Chief Robert P.G. Okara held as follows. Plaintiff's claim, therefore, succeeds to this extent. That is, that the deed of 1913, which is Exhibit A hereof, is valid and subsisting, and since at least one other party to that agreement has since been benefited by a revision of compensation payable, the plaintiffs ought in equity to be treated in the same manner. For the sake of truth, peace, and future generations, history must be told as it happened, not as some wish it had been.